I've said before that the Supreme Court is very likely going to gut the rest of the Voting Rights Act after they hear this case coming out of Louisiana, and after hearing oral arguments today, it looks like I was right. So that will allow white supremacist Republicans in mostly southern states to redraw their state maps to eliminate Black congressional districts. I want to make it really clear that this has been a goal, a stated and explicit goal of conservatives since the VRA was passed in the first place in the 1960s. And it has been explicitly a goal of John Roberts, the Chief Justice of the Supreme Court, since 1982, when he was a member of the Reagan administration. The VRA came up for recertification during the Reagan administration in 1982, when Roberts was just a lawyer working at the DOJ after he had finished clerking for Rehnquist. Rehnquist, who when he was a young lawyer wrote memos about how the Supreme Court decided Plessy versus Ferguson correctly and that segregation was constitutional. The VRA was amended during this administration. The amendments would allow voters to sue based on the effects of discriminatory policies in states, not just an intent to discriminate. And that is how we get racial gerrymandering being illegal. And that is what the Supreme Court is about to overturn. Roberts, working for the DOJ, wrote over 25 memos on behalf of the Reagan administration trying to stop that amendment from happening, saying it amounted to voting affirmative action. Roberts insisted that the amendment was going to result in population quotas or congressional quotas, an argument that most civil rights lawyers at the time found completely ridiculous. A compromise was reached by Bob Dole. He was a senator at the time, and he made the argument that now was the time for the Republican Party to erase its image of being elites who don't care about Black people and to accept the effects test of the amendments under the assumption that proportional representation or quotas would not happen. John Roberts was pissed. Reagan signed it into law, and John Roberts has stayed pissed ever since. So that's why we're here. John Roberts wasn't the only person pissed off. The Heritage Foundation, 1981. No pattern of discrimination case may be filed unless there is a clear proof of an intent to discriminate. Intent, not effect. This is a horse the Heritage Foundation has been riding ever since. So if they overturn this, it's unclear if they're going to do it fast enough to have any real effect on the midterms because some states' primaries will have already started. So they probably won't have enough time in a lot of states to redraw their maps that fast. There are also state laws in a lot of states and in state constitutions that will allow people different avenues to try to sue. When I say that we have never had free and fair elections in this country, this is the sort of thing that I'm talking about. During Reconstruction, despite the fact that they were guaranteed the right to vote by the 15th Amendment, Black men were prohibited from voting because of violence, brutality, lynchings, poll taxes, and literacy tests. That didn't really work out, so now white supremacist Republicans are trying a different tact. Your states draw your maps. I keep saying this, but your state and local elections are more important than federal elections. What happens in your state after the Supreme Court decision will be determined by whoever is elected into your state house. So that's where you should focus.